those signatures become ministerial. I value the intent of the, okay, I said that already. I support the Brown Act requirements and seek to adhere to its requirements in all my actions. I believe the Brown Act requirements were intended to inform the public, but were not intended to mire down the work of the boards and agencies in minutia. Therefore, I believe the workshops will help inform the board, staff, and the public regarding the Brown Act intents and requirements. And through this process, the board's work can return again to what's important in the, for our district, and that's the work around the students. Thank you.
Okay, other board comment here before we...
I just feel that we have a binding, we have 5 binding contracts that I do not want to bring back to the table.
Okay, just to comment here, first of all, we probably are making this far more complicated than it has to be. The issue is really around whether we want to cure and correct, and the community members have asked us specifically how to correct that action. The action that we take, and Mrs. Mayo's point is on April 23rd, these contracts were agreed upon. There is, again, if we're going to end up debating the legal merits of this, there are 2 different legal perspectives on this. And one is that the April 23rd discussion was around, first of all, it was a verbal agreement, and it was around extending the contracts. The complaint and the concern comes from the fact that this board did not hold a public discussion on the written contracts. And apparently those written contracts surfaced on December 6th, which actually leaves the board open to additional cure and correct demands should we not correct this. It leaves the board open to additional cure and correct demands in people saying that on December 6th, for the first time they saw the written contracts. That now brings the timeline way past April 23rd and opens us up to additional concerns about cure and correct demands. By taking action to place these contracts on the agenda, all we're doing is simply correcting and eliminating the possibility of any and all lawsuits from community members that violations have occurred. The act of placing the contracts on the agenda is the opportunity to hold the public discussion around those contracts that the complaint is saying, the demand is saying that did not get held. So it eliminates the risk of all lawsuits from the community members. No, folks cannot come back after the fact and say, well, actually, we didn't see those till December the 6th, so now I want to file a cure and correct demand. We've now, mushroomed into 2 of them, and conceivably could go to a 3rd, 4th, 5th, 6th, 7th. It will go on, could go on ad nauseum. The act of placing those contracts on the agenda eliminates the community concerns, eliminates a cure and correct demand, and does not jeopardize the outcome of those contracts. It's simply considering them in public discussion, and the complaint is that's the piece that was missed.
What would be the, we're going to consider them in public, what's that discussion going to look like? I mean, I don't understand what we're going to be discussing in public. Are we going to be discussing the moving costs?
We would be placing corrected versions of those contracts, because the severability that you're discussing, the idea is that some of these contracts have violations of Ed Code, violations of AB 1344, and because they're replacement rather than amendment contracts, there's not a separate page amending the changes in the contracts. They're simply been replaced by another contract. That could all be corrected and brought back to the board for public discussion. For the public, I think that when I read those cure and complaints, the public discussion is the piece they're concerned is missing. By bringing those forward for public discussion, by putting those on a public agenda, that is the correction. It's done, it's finished, it's over, and the public, has had their answer given to them. We have corrected the action. It is not about, we don't have to sit here tonight and prove there was a Brown Act violation. That's not a requirement of cure or correct. That's not even an interest that I would have, is to look at, are we guilty of something? Should we be punished for this? I'm interested in eliminating the risk to the district. of any additional cure and correct, of eliminating these two cure and correct demands. So simply placing the contract on the agenda eliminates that. It doesn't mean the board can't take action to approve those cleaned up contracts. That's the situation, Ms.
So
Denver.
could-
I'm looking to correct.
Could the board
In a
take
simple
action to deny those contracts?
Well, it opens it up for public discussion and board discussion. You know, and as Mr. Lawrence had said last May, the new board should consider that. Well, unfortunately, through this, it becomes a consideration of the new board, because the placing the contracts on there puts them before the public. That cures the concern that has been expressed, and it eliminates the community's concerns, and then the board takes action. But that's a separate item, and it's not what we're trying to attempt to do tonight.
If there was never any discussion about a Brown Act violation, can somebody just walk up here and ask for a cure and correct?
Anybody can file a cure or correct demand.
Or any time for any reason without having like a violation, there's no.
Well, it's linked to a Brown Act violation.
But then if it's linked to the Brown Act violation, wouldn't that have to mean was a violation?
This board does not, there is no, and that's what Ms. Brown was saying, there is no requirement to cure or correct to prove guilt or innocence. It's not about that at all. It's about, just as the Gilroy City Attorney said, we simply take action to correct it. We don't acknowledge there's any problem whatsoever. It's not about pointing fingers. It's about saying one simple action in cure or correct eliminates all potential for lawsuits from community members. And it simply says we're going to do it over. It's really a do-over. We're going to do it over.
If you worked for somebody and you had a contract with them, and a contract extension, and this kind of thing came up, would you think that was reasonable and fair?
Well, you're presuming an outcome. All we're doing is
No, I'm just saying,
trying to
that
correct
somebody
an
wants to
action.
bring your contract back and talk about, whether there's any ed code violations. Would you think that was a fair thing to do?
Well, that's a hypothetical that
Well,
I'm
no,
not
I'm
going to
just
go into.
asking,
Because the topic tonight is cure or correct.
Well, I'm trying to get, these people across from us, this is what we're doing. So I think that's a fair question.
Madam President, I would just like to point out the 30-day period for Wendy Lack's letter has already expired, because she presented that letter on December 10th, and today is January 14th.
Which is why it's so critical that I'm
I beg
suggesting
your
we
pardon.
correct.
The other point that I wanted to make, now that you've interrupted me, was that, I'll have to wait, I'm sorry.
I'm sorry to break it into your deliberations, but given the fact that Ms. Cooksey is not here, and I have to interject here, I think, I don't want to get into legal advice, but I think you have to realize that there are two different pieces. There is the legality of the Brown Act, the violation of the Brown Act, which is different from the AB 1344, the validity of the contracts. What the cure and correct process is meant to address is a violation of the Brown Act. How the contracts are written and all of that, those are valid issues, but they don't fall within the purview of the Brown Act, because that is a content of the contract issue rather than the procedure by which it was acted upon. I'm not trying to diminish the concern that the board has, but I think those are two separate issues. Additionally, we're getting into areas that are that are getting to be quite strategic.
Yes.
And potentially detrimental to the district's position in any kind of potential litigation. So I would urge you that one of the things you might want to consider, besides having an open session item, is the idea that we have a closed session meeting prior to having an open session meeting on this particular issue.
Okay, and tonight, again, the issue on the agenda is the consideration of two cure and correct demands. It's not the issue of the contracts that we seem to be getting into. It's a question simply for the board to decide, do we want to cure or correct the